Welcome to all our participants and our speakers to this post-conference policy dialogue through the African Cyber Law Conference. You would have known if you've attended some of our events already that this year the African Cyber Law Conference continued even after it happened in March 2026, because there is a pressing matter around AI in the legal profession. There's also been a pressing matter around AI and the South African AI draft national policy that was recently retracted. And so we saw the need to continue the conversations, critical debate on matters concerning AI governance. On the 8th of May, you'll remember we had a session specifically dedicated to AI in the legal profession, and we centered it around governing AI across the African continent. We had speakers from Kenya, Nigeria, Rwanda, Ghana, and Tanzania. And today we thought it would be fruitful to continue this conversation about AI use in the legal profession and have a bit of a comparative analysis. And so today I welcome you to the webinar on AI professional responsibility and the South African lawyer. And for today's session, I sit in a bit of an awkward position because I'm actually not the moderator. I would like to actually hand over to Professor Helen Cruz from Rhodes University, who is a non-practicing attorney and professor at the Faculty of Law of Rhodes University. She's also the editor of the book Legal Ethics in South Africa, which I might even want to raise to show you the copy. It's a very recent publication which has been launched this week. And she also serves as the review editor of the South African Law Journal and sits on the board of the International Association of Legal Ethics. Professor Cruz's research interests in artificial intelligence focus on its intersection with legal education and the regulation of the legal profession. Professor Cruz, can I hand over to you to officially chair this session?
Thank you, Nomalanga. Thanks so much to you and to Wits. Just to advise participants that Nomalanga and I go a little bit way back. We were at Rhodes together as colleagues, and she has gently but firmly pulled me dragging and screaming, kicking and screaming into the 21st century with her cyber law energy and my ethical unease, and that's how this has really come together. So this conversation, as Nomalanga says, really follows on from the African Cyber Law Conference. It goes from the African discussion to a North-South discussion, and particularly the focus here is on the different regulatory conditions in which jurisdictions operate. And I'm just absolutely delighted that we've been able to get on board speakers from 3 different jurisdictions. And then importantly, the institutional voice in South Africa, the LPC with Brian Mhlongo, and Nomalanga Mashinini in South Africa, talking about even without the regulatory conditions in South Africa, what frameworks are there that impact on AI and the legal profession. So, as I said, the central question is what lessons South African legal practitioners can learn from jurisdictions operating under different regulatory conditions. And so what I want to focus on is the concern of what a genuinely responsible, ethically informed use by legal practitioners of increasingly agentic AI legal systems might look like. And so what better place to start than to start with the European Union, with a very kind of regulated environment, the AI Act. And our first speaker is going to be Matthias Killian, and he's the Hans Soldan Professor for the Law and the Legal Profession at the University of Cologne. He's also my president of the International Association of Legal Ethics, and has spoken about technology and the law for well over, I think, 2 decades, or not quite sure on that. And he's going to set out the EU AI Act, where lawyers sit or don't sit in terms of the Act's risk categories and what it means for legal practice. We then go on to Iris Dormelard, who's a professor of legal philosophy and legal ethics, and the founding director of the Amsterdam Center on the Legal Professions and Access to Justice. And Iris was instrumental in getting me focused on AI issues when she organized an AI and the legal profession pre-conference at the ILEC in Amsterdam in 2024. She's going to talk to us about AI in practice in a European jurisdiction and concerns about over-reliance and automation bias, and if they're being handled, if at all. Thereafter, we're joined by Julian Webb. Julian Webb is a professor of law at the University of Melbourne. His current research focuses on ethics and the limits of AI augmentation in the courts and legal practice. What's really exciting is that he co-leads on the AI law and legal institutions research stream at Melbourne's Centre for AI and Digital Ethics. And so his jurisdiction fits a little bit more in the south with ours, but he will offer the Australian perspective, particularly from New South Wales. Am I correct there? I think I am. And then we come home to South Africa, and we come home with Nomalanga Mashinini from WITS, whose cyber law experience has been central in shaping this event and shaping many of the conversations we are having in the last 2-3 years. She chairs the annual African Cyber Law Conference. She's founded the WITS Image Rights Engagement Project to address AI-driven image theft. And so Nomalanga will be talking to us about the South African context, including what existing frameworks such as POPIA already require of lawyers using AI. Then our final speaker is Brian Mklongo, who is the youngest, most senior, if that makes any sense. He's the youngest senior legal advisor at the Legal Practice Council. He's the strategic advisor to the chief executive officer there, and we are just delighted to have him on board. He works across disciplinary enforcement, high-level advisory work, and leadership roles in the council's provincial and national structures. And he will be pivotal in offering a perspective of the Legal Practice Council's view of AI. I know they've just done a recent webinar on AI in the legal profession. And so I think the question then comes to whether the existing regulatory framework is sufficient, what more explicit guidance is needed for both individual practitioners and firm-led or firm-level responsibilities. So the way in which this webinar is going to work is we're going to have the first hour or so as kind of information gathering, and then get to our hopefully rich and engaging question and answer sessions. So each speaker has approximately 10 minutes. And then we're going to get on to that question and answer. So without further ado, let me hand over to Matthias. Matthias, thank you so much.
Thank you, Helen. Good morning, everyone. Thank you for having me at this webinar. European perspective on AI regulation offers some useful comparative insights as South Africa considers its own path forward. My focus today is on the EU's Artificial Intelligence Act, or Regulation 2024-1689, as it is called, and what it means practically for lawyers. I will walk you through the architecture of this landmark regulation, how it touches the daily work of practitioners, and where it falls short, but I can only give a very brief overview, of course, in 10 minutes. Some context first. The AI Act entered into force on August 1st, 2024, establishing harmonized rules for artificial intelligence across the EU, covering the development, marketing, deployment, and the use of AI systems. As an EU regulation under Article 288, it applies directly in all member states with no need for national transposition, though its provisions are being phased in over time. So why should a South African audience care? Because the AI Act is widely regarded as the first comprehensive legal framework for AI anywhere in the world, a critical reference point for any jurisdictions contemplating regulation. The central design principle is a risk-based approach grounded in the principle of proportionality. Not all AI systems are treated alike. The regulation distinguishes 4 categories of risk. First, AI systems or practices posing an unacceptable risk. They are outright prohibited under Article 5. Second, high-risk AI systems under Article 6. They are permitted but subject to extensive requirements and obligations. Third, AI systems posing a limited or minimal risk, governed primarily by transparency requirements under Article 50. And fourth, a newer category, general purpose AI models, or GPAI, which carry what the legislator terms systemic risk, and they are addressed specifically in Articles 51 and following. This structure matters because it determines which obligations fall on which actors, and that turns on a fundamental distinction between providers and deployers. A provider develops an AI system or general purpose AI model and places it on the market or puts it into service under its own name or trademark. The deployer uses an AI system under its own authority in the course of a professional activity. So where do lawyers fall? Most are deployers. They use commercially available tools for legal research, for drafting, due diligence, or case analysis, but neither develop or brand them. Some, however, may qualify as providers. For instance, a firm operating as a debt collection service that offers AI-based legal tech to the market, or one that develops an in-house system for its staff. There, the firm becomes a provider with all the obligation that entails. The distinction matters enormously. Providers face significantly heavier compliance burdens than deployers, particularly when their systems are high risk. I will take the categories in turn, starting at the top. Article 5 lists prohibited AI practices, those carrying unacceptable risk. For the most part, these have limited direct relevance to practitioners. But one scenario is worth flagging. Suppose a firm deploys an AI system for automated initial case assessments. If it, by way of manipulation, encourages individuals to retain the firm or pursue hopeless litigations, it could fall foul of the Article 5 prohibition on manipulative techniques. An edge case today, but as AI becomes more embedded in client-facing services, the line between helpful guidance and manipulative influence will demand attention. The second tier, high-risk AI systems, is where things get interesting, and some would say problematic for the profession. The Act classifies AI used in the administration of justice as high risk. Systems that help judicial authorities research and interpret facts and law and apply it to concrete cases, they fall squarely within this category. But, and this is a significant but, the classification applies only to judicial authorities, not to lawyers. As an explanatory note makes clear, the high-risk designation in the justice sector targets courts and similar bodies, but not the legal profession. This distinction has drawn criticism. Judicial AI is classed as high risk because it can affect the rule of law, individual freedoms, and the right to an effective remedy. Yet AI used in legal practice touches the same values. The risks of error, bias, and opacity are no less significant when a lawyer advising a client relies on AI than when a judge deciding a case does. Some see this as a normative inconsistency, a gap for future revision. The lesson for any jurisdiction designing AI regulation is whether lawyers should meet the same standards as judges, and this is a question you will need to confront. A brief word on general purpose AI models. The GPAI category, models designed for a broad range of purposes and capable of being integrated into other systems. JetGPT being the obvious example. These obligations fall on providers of GPAI models. Since lawyers are typically users, not developers, they generally do not apply directly to practitioners, though lawyers should understand them since they shape the ecosystems of the tools they rely on. We now reach the category most relevant for the vast majority of lawyers, low-risk or minimal-risk AI systems on which the Act imposes relatively light obligations. Two, however, deserve attention. The first is the duty to ensure adequate AI competence under Article 4. Providers and deployers must ensure that personnel can use AI systems in an informed manner. Under competence means the skills, knowledge, and understanding that enable deployers, taking into account their respective rights and obligations, to make informed use of AI systems and to become aware of the opportunities and risks of AI and the potential harm it can cause. The Act does not prescribe how this is achieved, leaving it to each firm, but the implication is clear. Firms must invest in training so that people understand how their tools work, what they can and cannot do, and the risks involved. The second obligation is transparency under Article 50, where the requirements differ for providers and deployers. I will focus on deployers. Article 50 imposes a disclosure obligation for AI-generated or AI-manipulated content published to inform the public on matters of public interest. Its exact scope for content lawyers publish, say for marketing, remains unclear at this point. Importantly, the obligation does not apply where the content has undergone human review or editorial control. To draw this together in its current form, the Act imposes relatively modest direct obligations on lawyers, essentially the duty to build AI competence under Article 4 and the transparency obligations under Article 50. The more demanding provisions, risk management, documentation, monitoring, fall mainly on providers of high risk and general purpose AI, not on lawyers acting as deployers. But this is no green light for complacency. 3 points are worth reflecting on as South Africa develops its own approach. First, that AI used by lawyers is not classified as high risk does not make it risk-free. When lawyers use AI to advise, draft, or decide strategy, the stakes for individuals and the rule of law can be as high as when judges do. Second, the duty of AI competence is the single most important takeaway for any legal profession anywhere. Lawyers who use tools they do not understand are not merely non-compliant, they are failing their clients. Third, transparency about AI in legal practice is not only a regulatory obligation, but a matter of professional trust. Clients, courts, and the public deserve to know when AI has shaped the work product they receive. Let me conclude by putting these findings into a broader context. The relatively limited relevance of the AI Act for the daily practice of law means that lawyers and their professional organizations in the member states are currently struggling whether the existing national legal framework for legal practice, rules on professional responsibility, contract law, competition law, is adequate to deal with the new challenges, or if an additional framework is required. Those who feel that additional legal guidance is required are faced with difficult questions. Should it be soft law or hard law? Should it be activity-based regulation or entity-based regulation? Should it be regulation by sector or cross-sectoral regulation? These are questions others will touch in the following presentation. My time is up, so thank you very much for your attention.
Matthias, thanks so much for keeping us on track. I see you've shared your slides, but you didn't use them. I'm wondering if we can afterwards just send them out to participants.
Absolutely. Yeah. Yeah.
Right.
Absolutely.
Great. So you raised the idea of the existing framework and whether there's an additional framework necessary and how it should look. So I want to turn now to another European jurisdiction, and that is in the Netherlands with our next speaker, Iris, who's going to be talking to us about perhaps trying to respond to Matthias's difficult question, but sort of giving us an insight into the issues faced in the Netherlands. Thanks very much, Iris.
Thank you, Helen. And also thank you for the organization. It's great to be part of this webinar. Just as a background, I'm also affiliated with AUGASOC. It's a largely publicly funded inter-university consortium that examines the societal impact of algorithmic systems. And one of its key objectives is to explore how public values can be safeguarded in an increasingly digital society. And we are always keen to collaborate with colleagues abroad, also because of the importance of, comparison, international comparison. So also on behalf of my fellow researchers, I hope that today's discussion will be the beginning of this important intercontinental conversation, North-South conversation on this topic. So I was asked to say a few words about the development in the Netherlands regarding the use of AI by lawyers, in which and how these developments and how these practices of AI use are being regulated, or perhaps not yet or not sufficiently regulated. So I will address three subtopics, so to say. First, I will briefly sketch a bit of background, broader context surrounding the debate on the use of AI in the justice system in the Netherlands, and also how it's shaped by some specific features of the Dutch justice system and the way it's working currently. And then secondly, I will look at how AI is used in legal practice in the Netherlands. And finally, I will discuss also briefly the emerging regulatory framework governing the responsible use of AI by lawyers in the Netherlands. So first, a bit of background. In the Netherlands, we are currently facing a huge access to justice challenge. So in some regions, there are only a handful, sometimes even half a lawyer per 1,000 citizens available to meet citizens' legal needs. And against this backdrop, it's of course not surprising, and also I see similarity, of course, elsewhere in the world, that a rather techno-optimistic perspective exists within the access to justice movement in the Netherlands. AI-driven legal tools are developed by startups as a way to support citizens who cannot afford legal representations or for whom a lawyer is simply not available. At the same time, the Netherlands also has a very strong legal industry with quite a few internationally oriented elite law firms. These firms are already far ahead also compared also to the many smaller practices in terms of technological adoption, and are using AI, of course, to strengthen also and maintain their position in an increasingly competitive legal service market. And unsurprisingly, in this sector, one of the recurrent topics is the potential impact of AI on legal fees and legal billing models, although this topic is hardly openly discussed, but still really topical. At the same time, in the Netherlands, also really cautious attitudes prevail towards the use of AI in the justice system, in particular also within legal academia. And this caution is partly rooted in the Dutch experience with algorithmic decision-making by the state. We had huge miscarriage of justice, the child care benefits scandal, in which due to governmental decisions, lives of tens of thousands of citizens were really destroyed, also because of the use of discriminatory algorithms. And there are more examples of Dutch municipalities using discriminatory algorithms. So therefore, among the Dutch public, there's quite a bit of caution against this use of algorithmic AI in the justice system. And more recently, there were ample incidents of Dutch lawyers, using false outputs from Gen AI in documents in legal proceedings. And these lawyers, strong criticism by the judges, the presiding judges. So secondly, how is then AI currently being used in legal practice? Well, recent research shows that approximately 60% of Dutch law firms already use AI for tasks such as legal research, document analysis, drafting, and client communication. Another 20% plans to adopt AI tools in the near future. However, and here there's then a discrepancy, there are significant differences between types of firms. Sole practitioners are relatively less enthusiastic or less prone, or they have less resources to use AI tools. Only about 1/3 currently uses them, compared with 2/3 of medium-sized firms. And ChatGPT and other general-purpose generative AI tools are far the most widely used, with adoption reported by 80% of firms that use AI. This brings me to the regulatory side. Last year, the Dutch Bar Association's Working Group on AI and Digitalization published recommendations on the responsible use of AI in legal practice. The report highlights how core professional values, so sectoral specific values one could say, such as competence, confidentiality, integrity, loyalty, and professional independence, may be affected by the use of AI systems. And in this regard, one perhaps striking recommendation that links also to the remark Matthias made is that lawyers should be transparent regarding the use of AI vis-à-vis their clients. However, in this regard, questions remain as to when exactly lawyers should disclose their use of AI to clients and how detailed such disclosures should be in practice. The report shows, the recommendations, I should say, of the Dutch Bar, shows strong overlap with the CCBE guide, that of the Council of Bars and Law Societies in Europe, on the use of generative AI by lawyers. And then one of the criticism from practitioners in the Netherlands, and particularly also from larger law firms, is that these Dutch guidelines, compared to the CCBE guidelines, focuses more heavily on risk, while paying less attention to opportunities and practical guidance as to how to mitigate these risks. It is said to be more a warning document than a framework for responsible innovation in legal practice. For example, the document warns about risks, and here is an answer also to Helen's question about the risk of sycophancy and automation bias and other biases. So the document, the recommendation, warn about these risks, but it does not really tell something about how exactly to mitigate these risks in day-to-day practice, otherwise than just, for instance, being aware of the risk of sycophancy as part of the value of independence, and also being aware as a lawyer as part of the value of loyalty of algorithmics potentially being biased. So there's a focus on this call for more awareness. And also, and finally, what is notably contrary to the regulatory framework of the CCBE document, the Dutch guidelines and recommendations do not say anything about the more systemic or societal risks that comes with the increasing use of AI by lawyers in practice. Thank you.
You're muted.
You're on mute.
Sorry, Iris, you've still got 3 minutes.
Sorry, but I finished already.
Oh,
so,
that's excellent. Oh, well, there you go. Oh, great. All right, let's get straight on to Julian Webb. Julian, over to you.
Thank you very much, Helen, and to my fellow speakers as well. And thank you for having me here tonight. Tonight in my terms, anyway. So it's somewhere about 7:30 in the evening where I am. So look, I also have a set of slides, but I'm not going to run through those because in part I've got too many. But I will share them with you afterwards. But I also wanted to have a bit of more flexibility to respond, I think, to some of the themes that have emerged from the first two parts of our discussion tonight. I am, as Helen said, going to talk about AI regulation in Australia with a very specific focus on lawyers and to some extent the courts as well. I subtitled this part of my presentation as Playing by the Australian Rules. And if any of you have ever come across, when we talk about Australian rules in Australia, we're talking about Australian rules football. Don't know if anyone else would have ever come across that one. It's not soccer. It's not rugby either. It's kind of somewhere between the two with a bit of added violence thrown in for good measure. And maybe that's not such a bad metaphor to kind of start discussing where the Australian system is currently, hopefully minus the violence, in its AI regulation journey. So I am going to start with a very brief bit of background looking at AI regulation in Australia more generally, and then move into the kind of lawyers' legal ethics terrain, looking at litigation risks and guidance very briefly, conduct rules and guidance also pretty briefly, and some questions that I want to pose around where we go next and reforms. But following from Iris's point, I'm going to start with a couple of, I think, quite key figures that are worth picking up. Australia has a reputation reported in some quite good data as being one of the least publicly trusting societies when it comes to AI. And yet, interestingly, a study at the beginning of this year by one of the market intelligence agencies, not one of the AI companies, said that by the start of 2026, already 77% of Australian lawyers are using generative AI tools for some work purposes. So we are high relative to quite a lot of systems in terms of the pace and scale of adoption. Quite a lot of this is formal AI use, but we're also aware of problems with what we call shadow use, people using generic AI tools for legal purposes. And I'm sure you'll be aware this is where more and more of the problems with generative AI tend to arise. Though the jury is still very much out on a lot of the more specialist technology and how reliable that is. So we're not only high on the level of usage, we're also high on the level of problems. It's been estimated by Damien Colotin, a French academic who's trying to run an international database on these things, that there's already been 74 cases of reported AI hallucination in Australian court proceedings, and that's as of May 2026. Now, for in global terms, a relatively small jurisdiction, that's a lot of cases. We're quite well up there. So how are we dealing with these sorts of problems? If you start at the kind of meta framework that Matthias was talking about, we don't have a standalone AI Act. We are still in Australia adopting what is optimistically perhaps called a technology neutral approach, and that means we're relying on existing key legislation for much of the framework, and then an amend and adapt as we go along approach thereafter. So a lot of the heavy lifting is still being done by legislation like the 1988 Privacy Act. That was amended somewhat a couple of years ago to take some account of the growing technological risks. So that covers off a lot of the personal information and a fair amount of privacy by design regulation to address the privacy risks raised by AI and algorithmic decision making. We have at a federal level Australian consumer law, which applies to misleading or deceptive AI AI outputs and algorithmic bias, problems within the consumer space. We have obviously our own copyright legislation, which governs text data mining and AI-generated content. At a patent law level, we have our own case law, which says AI-generated inventions are not patentable. And otherwise from that at the moment, we're operating very much at a federal level via a high-level ethical framework and putting a lot of faith in a new AI Safety Institute, which is apparently going to do quite a lot of the groundwork going forward, and that's only just come into operation. So where that leaves us in relation to legal services sector is that within that federal framework, sector level regulation is still very central. It's the way to go. And for the legal sector, that's messy because legal sector regulation is a state and territory competence. It's not a federal competence. So that means it's up to each of the 8 jurisdictions that make up federal Australia to work it out pretty much for themselves. And so what we're seeing is a lot of players starting to operate in this space. So we're seeing litigation guidelines being produced by the courts, and we're seeing at the moment predominantly soft regulation guidelines coming from the professional regulatory bodies. The general approach being taken at the moment is there has been no strong sense that we need to change the conduct rules themselves. And indeed, I think quite a lot of the smaller regulators are still pretty much in the space of taking a wait and see approach and seeing what everyone else does before they move. New South Wales and my own state of Victoria are the 2 largest jurisdictions, and they are also part of what we call the uniform law jurisdiction. So New South Wales, Victoria, and the state of Western Australia have all combined to adopt a more or less common set of laws and regulations, and it does mean the regulators in those 3 states are tending to coordinate and move in concert. Sometimes that does mean moving at the pace of the slowest. But as Victoria and New South Wales are the 2 largest jurisdictions in Australia, they are tending to do some pretty good work and forward-looking work in this area, and I'll touch on that fairly briefly. So what we're seeing in terms of litigation guidelines coming out of the courts, and this was where a lot of the initial activities started. And in fact, the Victorian Supreme Court, I think, was pretty much the first to come out with guidelines in May 2024. These took a very permissive approach to AI use, with disclosure being encouraged. Those guidelines have been replaced by a formal practice statement in 2026, which draws on a Victorian Law Reform Commission report, which has made some also interesting recommendations, which I'll touch on very briefly in the reform sector. What we're tending to see in the court space is a kind of a certain amount of overlap. So there's a focus on duties not to mislead the court, and that's reinforced in Victoria and New South Wales in particular by civil procedural rules, which require litigants and parties to have a proper basis, i.e. a properly arguable legal case before commencing civil litigation. It's below a prima facie case standard, but it is meant to be some kind of check that people are not just running empty litigation. The Victorian approach advises caution on AI assistance with evidentiary materials, but there's no upfront obligation to disclose AI use, but the court can ask for evidence of verification. At the other end of the scale, the New South Wales Supreme Court put out its guidelines in beginning of February 2025. Those are the most prescriptive in Australia currently. So they allow AI use for things like basic drafting, summarization, and research functions, but essentially prohibit the use of AI in producing any evidentiary material. AI can also only be used in expert reports with leave of the court. And there is, again, no general disclosure requirement, and that set of guidance is under review. What we've tended to see in the courts so far across Australia is a fairly robust approach to the legal hallucination cases. There is a tendency where lawyers are involved to make reports from the court to the regulatory authority in the relevant state. And in the first decision, which was decided again in Victoria, a case called Dayal, the regulator didn't take it up to the tribunal, but did deal with it under their own regulatory powers, and in fact restricted a fairly senior practitioner's practicing statement to supervise practice for a not insignificant period of time. So there is a bit of an evidence for a hardline approach here. If we look at professional conduct guidelines rather than regulation itself, we've had guidelines from the uniform law regulators. As I say, that's New South Wales, Victoria, and WA, and that's been pretty much copied by one of the smaller jurisdictions, the Australian Capital Territory, but no one else has actually produced separate guidelines at this stage out of the 8 jurisdictions. Those guidelines tend to focus on the kind of big 4 duties: maintaining client confidentiality, providing independent advice, and again, not checking AI outputs, not verifying AI outputs is seen in these jurisdictions as a failure of the duty of independence. It's also generally seen as a failure of integrity and a failure to deliver legal services competently and diligently. The other area where we see the conduct rules themselves being referenced is in relation to costs. There is a professional obligation, as there is in South Africa, on ensuring costs are fair, reasonable, and proportionate, and that's built into our uniform law and mirrored in other jurisdictions as well. Very little discussion of that one so far, so I think a similar experience to the Netherlands in that respect. The Uniform Law Statement also recommends that firms consider creating risk-based AI policies, that they limit AI use to lower risk functions, and they adopt principles of transparency with clients and with others where required. And that's where I think a lot of the activity going forward is probably needing to be focused. I think there are significant issues that we haven't fully addressed yet around transparency, disclosure, and client consent. And I know this is also an issue of discussion in South Africa as well. Obviously, disclosure and the need for client consent are not the same thing. Disclosure does not, I think, necessarily imply some degree of formal client consent. So even if we start from an AI-based idea that transparency is a good thing in letting clients and others know that we're using AI, it doesn't necessarily follow that we need formal consent from clients. Or do we? Is there a case for client consent in general? Is there a case for it where a client wishes otherwise, for example, to opt out of AI augmented services? Not least because that could have cost implications, or where a decision around AI use may have specific risks for the client or a related third party. And again, increased costs could be a risk, but if there are particular reliability concerns or whatever, should that be disclosed? or confidentiality risks, which may be associated with client behaviours as well. I think those are important questions which have yet to be resolved. In the slide deck, I put an AI checklist that Queensland has put together, and there is an example of an AI disclosure opt-out consent clause that they're recommending, and you might find that useful. I think one of the questions which isn't really being widely addressed yet, and this is my final point, I'll finish on this one, is the question of whether or not there ought to be any kind of express duty to verify. Now, at one level, that sounds like it's doubling up on the traditional obligations in some way. You could say a lot of that's covered off by independence and the duties of competence and integrity. But I do wonder, looking into the future, and particularly when we see lawyers having to engage and deal with more and more problems of deepfake legal documents, whether there is separate value to that kind of duty. That in particular hasn't been picked up elsewhere. The Victorian Law Reform Commission has said we need to be looking regularly at our Evidence Act and thinking about the problems, particularly in litigation around deepfake evidence. But it may well be that document reliability as well as legal information reliability is going to be a broader problem than that. I'm going to leave it there. Thank you.
Thank you so much, Julian. I'm just going to pause here to say that we've reached the end of the north and we are now entering the south. But I want to also say that there is a Q&A block, or there's availability to actually just type in, participants to type in the questions, so that when we get to discussion time, we can raise those questions with the presenters. I also wanted to then go straight to Nomalanga, but I wonder, Nomalanga, if you know whether there has been any count of the hallucinated cases in South Africa. We know of the more famous ones and the more recent Libber versus Volkswagen hallucination with the magistrate, but that is one thing that is very interesting. And the other implied interesting issue that Julian raises is the firm-based work and how that fits within a jurisdiction where there's lots of single practitioners. So interested to hear there what you have to say. Thanks so much.
Thank you for putting me on the spot, Helen. I'm actually appreciative that I'm coming right after Julian, because what he ended on about verification is one of the propositions that I want to touch on. And as for the count of how many instances we've had in South Africa, I do believe we're sitting now on roughly 5, especially if we include now the judge's slip. But today I'm not going to talk about the judge's slip, because remember, Helen, after this, we are going to have a discussion, a special webinar on judges' duties in the same context of AI use in legal practice. So I've left that for that later discussion. Today, I'm going to bring the South African perspective. While we do not have an AI statute, although some people might say not yet, we also don't have an AI policy on the table anymore. It was ironically retracted due to hallucinated sources in the draft AI policy itself. But the absence of an AI law is often misread as an absence of regulation. I've seen this even in my niche where I deal with synthetic media regulation, excuse me, and I've had to many times address this misconception, especially because if we go back to the foundations of South African law, our legal system is a mixed hybrid system, right? And so even these duties that bind lawyers in South Africa should also be seen through that lens when especially AI comes into the fore. So we are not without regulation, even though we do not have AI statute or AI law. But a legal practitioner who uses AI tools is already bound by the duty of competence, duties owed to the court, and I'd like to also argue bound by the Protection of Personal Information Act. So the question before us is not really whether there's regulation, but rather the question is whether the duties that already bind us are adequate to deal with the conduct that we are seeing now. So first, I want to set out what our existing law already requires of lawyers, and I'll do so very briefly. And then I will show where these requirements start to feel or seem or in practice show up as inadequate. And the question of what the regulator should do, I'll leave to our legal practice counsel colleague in the room. But I'll keep returning to the point that as these AI systems become more agentic, meaning they act across multiple steps without the human having to sign off at each one, more and more, the real question is not really what the machine can or cannot do. It is more about what the lawyer remains accountable for. And in the context of my talk, what the South African lawyer remains accountable for. So there are duties that already bind us. The first set of rules we see are the professional duties. And no need to really reinvent the wheel here. We know that these duties arise out of a contract of mandated common law, the duty to carry out the mandate and act with a reasonable skill, care, and knowledge, and to act honestly and in good faith, and to also account to the client. That is part of the foundational duties and principles that we know of, and we've seen them, we've taught them, and lawyers practice them in South Africa. Then you've got the code of conduct that is enforced by the LPC, which deals with a number of issues relating to competence requirements, the obligation to do competent work and to remain abreast of the law. You also see duties owed to the courts, which makes the client's interest paramount, but always subject to the court and the interests of justice and the law. Confidentiality also comes up, and privilege coming up under this code of conduct, that we are not to, breach the confidentiality between client and attorney. And this is relevant when you think about issues relating to personal information processing that I'll touch on later. And you also have the duty to not mislead the court, and also quite relevant as it came up in the first case where we had AI hallucinations in South African courtrooms. And so when I listened to Julian mention this duty to verify, I look at our principles in South Africa and I think, well, then the duty to verify is not explicitly mentioned under any one of these duties, but surely it is implicit that if a lawyer uses AI for whatever purposes in their work, given that the work is of a professional nature with duties owed to the client, to the court, then surely the duty to verify should be implied. So I'm not really appealing to a new standard when I hint at the duty to verify as well, which is why I was so glad that Julian mentioned it, because it seems the thinking north and south is starting to really converge. The second issue is the issue of data protection, which of course in South Africa is under the Protection of Personal Information Act 4 of 2013. So if I take my client's facts and I put them into an AI system, surely some of these facts contain personal information. Depending on how far I have anonymized or de-identified some of this information, the issue may actually be more serious in some instances where lawyers are not sensitive to how the Protection of Personal Information Act places responsibilities on them to ensure that such personal information is protected. And that is one of the most, I would say, threatening issues for a client when a lawyer feeds an AI system whatever issues or content relating to their matter, right? And I point it out because the moment you enter that territory as a lawyer, You've decided the purpose and the means for processing of personal information, making you the responsible party under the POPIA. Therefore, you become answerable for the lawful processing of that information, the security safeguards that apply to that information, and also the terms on which any operator handles that information. And in instances where the tools sit offshore, which is often the case, looking at it from our perspective in Africa, most AI tools we use come from the US, come from China. So there's a question of cross-border transfers of personal information outside the Republic that is also equally binding on the South African lawyer. So these compliance and governance issues are not separate if you think about them. In fact, lawyers should read them as one, right? As one system that deals with how their professional conduct should be managed. So the lawyer who chooses the tool, who determines what goes into it, is the one whom we should hold accountable. The courts are already engaging this matter, and I'm giggling because I remember when the AI hallucination story broke about the draft national AI policy in South Africa. Everyone was quick to call it an embarrassment and, ooh, the irony and blah, blah, blah. But I sat there thinking, this is not a new thing. Although having company in a wrong thing doesn't make it right, it is not a new thing because our courts have been dealing with this problem since 2023. And while we don't have the leading score, if we're keeping score, I've seen a database of the same problem of AI hallucinations in court documents. And on the database, the United States of America is the leading nation where you've had more than 700 instances of the same problem. Probably also owing to the fact that, you know, you're dealing with state courts in 50 states. So obviously they've got a lot more courts in that single country. And I wonder if in South Africa, if we had a lot more court systems and a lot more efficient reporting, if a lot of this would start to surface. But anyway, since 2023, we've had this problem. But it didn't start as a problem, which is also quite interesting to me when I think of it as a story of AI hallucinations in court. I remember Makunga versus Belaquin. In 2023, the court dealt with a litigant who was representing himself, who filed heads of argument and prepared them with the help of Google. The court did not condemn the AI use in that instance. It accepted the heads, and even the court made a remark that it had seen worse heads of argument from members of the bar. And this is because one man who is not even ordained, trained to be a lawyer, to be a legal practitioner, took time to check that his sources were real, took time to check the accuracy of what he was presenting before the court, having been abandoned by his representation midway through the process. So the first lesson that we had in South Africa is not about, you know, the negative outcome of AI use. In fact, it's a lesson of justice played out, where AI assistance helped this particular plaintiff. There are some wrongs that have appeared since then. And in the same year, Parker versus Forsyth was the first judgment in 2023, where the court found that attorneys had used ChatGPT and the authorities they cited did not exist. However, when the opposing counsel pointed out how this should lead to punitive costs, the court found that actually there was no intention to mislead the court, as the court found the conduct of the particular legal practitioners, and the court declined to give cost de bonis appropriis, and thus, you know, the client was the one who paid the wasted costs in that instance. And the court found that embarrassment was punishment enough. Embarrassment we saw with the AI draft policy, but with the government, it seems you get suspended very quickly, as we've seen with the Department of Communications and we've seen with the Department of Home Affairs in South Africa for the same conduct. Nevertheless, in 2025, Mavundla came with a more, I'd say, and humbly position with a more level-headed response. Because in Mavundla, the court actually even flagged that the Parker leniency is unacceptable because you can mislead a court even through negligence. It is not always a question of pure intention. Because the thinking that I lean on and that I appreciate the Mavundla court to have highlighted is that when you prepare a document, even with my students here in university, when you prepare a document and you submit it to me as an assessment submission, I'm taking it that you read the material that you've cited. And you are representing to me as well that you've read the material. And the same applies even with the practitioner presenting certain citations to the court and to their opposing counsel. And so I welcome the Mavundla critique that there's a tacit representation that actually happens there, and they can even mislead through negligence, even where intention is not proven. Later on, we've seen also two other cases, northbound, Roux versus Van Gienen. Roux versus Van Gienen is the latest one that happened early 2026. Again, fabricated sources came up. And what we see as a pattern emerging from these three more recent judgments is that the courts are now referring such lawyers to the Legal Practice Council to address. So while we do not have a settled principle, we do see that there's a clear matter of referring the matter to the Legal Practice Council. Helen, I see your video is on. Are you about to tell me to stop? I can't hear you.
So you've got about a minute, Nomalanga. Thanks.
Let me make the point. So I'm one who believes that much of the anxiety about AI use in practice has also been erroneously been clouded by the issue of opacity. And I want us to be clear about the claim about opacity or an opaque system. Because while, the black box story is about how you are not able as a human to verify what happens in the AI system, how it makes decisions, how it reasons, how it reaches a certain output. Sure, you can't inspect the internal reasoning, but that doesn't take away from what I, as the human, have inserted as a prompt or even as documents or whatever I may have prompted it to do. And that should remain traceable. It should remain explainable. And accountability should not be offset by the mere fact that one has used an AI tool. And this is where I would call for agency, that agency can address the opacity issue, right? Because everything on the side of the South African lawyer remains open to inspection. Every step they take remains open to inspection, and they should be still accountable for what they do there. So if a lawyer does not verify, had they verified the sources, then they would have found out that the judgments do not exist. And that, to me, is not even an AI problem. It's an ethical problem. I'll stop there, Helen.
Thank you very much. And we'll definitely return to this agency can address opacity. On to Brian. Thank you very much.
Thank you so much, Helen. I think Nomalanga has covered most of what I'm required to talk about today, being the regulatory perspective on AI in the legal practice. I'll start by just stating that the Legal Practice Council is the single statutory regulator of all attorneys, advocates, and candidate practitioners and juristic entities established under the Legal Practice Act. The Legal Practice Act has subordinate legislations such as the Code of Conduct, which is binding standards of professional conduct for all practitioners, and also has the Legal Practice Council rules, which are rules of practice, discipline, and accounting under the Act. as all the speakers have said, AI is already entering the legal space. The question is how legal practitioners remain accountable when they use AI. The regulatory choice is between reactive discipline after harm or practical standards before harm. And a credible South African response should be protect the public interest, maintain trust in the legal services, and still allow the profession to use technology to improve quality and access to justice. The mandate of the Legal Practice Council is to promote and protect the public interest while preserving the independence and integrity of the profession, determine, enhance, and maintain appropriate standards of professional practice and ethical conduct, and also promote accessible, sustainable training and legal services in the Constitution, the rule of law as an anchor. AI governance for legal practitioners must therefore be profession-specific. It should translate existing duties into practical obligations rather than to create technology-specific rules that become absolute pretty quickly. For AI enabling work, the existing duties translate into 4 concrete disciplines, which most of the speakers have already mentioned, being integrity, competence, confidentiality, and the court and justice. Thus, legal practitioners are expected to verify every legal proposition, citation, and quotation against authoritative sources. They are encouraged to protect privilege, confidentiality, and personal information before uploading anything into an AI tool, and to exercise independent judgment and do not outsource legal reasoning or professional responsibility. There is no regulatory vacuum in the perspective of the Legal Practice Council, as the Code of Conduct is written in terms of duties and not devices, and those duties apply to AI-assisted work without the need for any amendment to the Code of Conduct. Because an AI is a tool, and responsibility for the work is non-delegible. Anchored in paragraph 3 of the Code of Conduct, legal practitioners are required to have honesty and integrity, to put client interests as paramount, and to protect the profession, which means basically that they are required to maintain the highest standards of honesty and integrity in all professional work that they do. Their work should always be subject to the duty to the court and the interest of justice, and they should do nothing that could bring the profession into disrepute. We've noticed that the risk is really the tool alone, but it's also usually the absence of professional controls around the tool itself. And as the regulator, we are required to also ensure that there are regulatory controls within the legal space in using artificial intelligence to avoid the issues as mentioned, such as hallucination. We need to make sure that there's verification discipline. With regards to confidentiality, the use of POPIA like tool selection, and over-reliance to deal with it using human supervision. And to avoid biasness, we should ensure, especially in the South African perspective, that primary South African sources and context is utilized. The stronger regulatory anchor is responsibility, as mentioned. disclosure may be required in specific circumstances, but disclosure alone does not verify or supervise, protect data, or make advice competent. So accountability cannot be transferred to the machine, or but it's to the person who's using that specific tool. What the Legal Practice Council as the regulator would expect from practitioners and firms is a defined permitted tools, prohibited use, confidentiality rules, and approval levels, which means legal practitioners and firms should adopt an internal AI use protocol. They should check every authority quotation and material, factual propositions against primary sources, and the use of COPIA cautious tool selections, and anonymization and access control, and to provide a lot of training and supervision to their staff and candidate legal practitioners, and also to themselves as legal practitioners to ensure that they know how to use and the limitations of that specific AI tools are. And most importantly, it's always accountability. When looking at the principles that the council or the LPC would likely use to guide, is to avoid reinventing the wheel by just providing guidelines, which the council is also currently considering in drafting and proposing to the profession to consider, to build on the Legal Practice Act, the Code of Conduct, and the rules rather than to duplicate them, and to regulate the conduct and not the tools that are being used, and only as far as genuine risk requires, and to provide practical guidance that keeps pace with the binding rules reserved for what guidance cannot reach. And in closing, I would say what the LPC also considers is whatever form it takes, the practitioner answers for the work to the client, the courts, and the council. And the tool is new, but the duties that a legal practitioner is expected to abide to are not. So in closing, the regulator only focus on the conduct of the legal practitioner himself and not the tools that they have used in regards to AI use. Thank you.
Thank you, Brian, so much. It's wonderful to have the regulator on board and to get the views of the regulator. And this has really been a theme that comes across all the speakers as to, starting with Matthias, is to say, is there additional, you've got your framework, the overarching framework in the European Union. We don't have the overarching framework in Australia and South Africa, but we do have other forms. We've got practice directions, particularly Julian mentioned practice directions in the courts. We've got statutes that govern privacy, copyright, etc. But they don't. One of the things that concerns me is that those statutes were never drafted with the use of AI in mind. That was not the sole purpose. The purpose was protection of privacy or protection of copyright. So a quick round between all the speakers before we get to the participants as to what the ideal frame would look like. Is it sufficient to rest on the existing framework in your particular jurisdiction, or do you think an additional framework is required? And if you do think an additional framework would be required, is it an amendment to gazetted code of conduct rules, or is it soft law? So all of that, starting with you, Matthias.
We've had this discussion in Germany, obviously, for quite some time. I think the general feeling now is that, in a way, AI is really new and posing new problems, but to some extent, it's also there's a German saying that says it's old wine in new bottles. So a lot of problems relating to disclosure, to confidentiality, etc. They are not new. It's a new way of non-legal outsourcing, as we call it. In the past, you outsourced part of your work to non-professionals, which raised problems of confidentiality, for example. In the past, you used legal assistants, for example, or law students in your law firm, and they might, produce hallucinated work as well. And so the question is always, we are discussing now, well, if we introduce sort of a bunch of new rules, do they only apply to AI then, or are there sort of similar circumstances in the analog world, so to say, where these would need to apply as well? I think that is one problem we are discussing at the moment. I think the other is, a lot of those problems are not really, if you look at them closely, are not exactly lawyer-specific problems, but are problems in the professional world. Also, we have similar problems with health professionals, etc. And I think what we're beginning to discuss now is it a good approach that each sector starts making up own rules, which may come into conflict at some point, or do we need some sort of overarching framework on a national level, in addition to the overarching framework we have on EU level? I think that's a problem. There is also another problem, I think, that needs to be considered. How do we deal? It's a digital service, so it can very easily be constructed in a way that it becomes a cross-border service. And how does it work then with conflicts of law? And particularly, digital services in the EU follow the country of origin principle. So they are sort of regulated based on the rules of the country of origin of the digital service. So if the digital service is targeting another jurisdiction across a border, the question is, how do you deal with that if the rules in the country of destination are different than the country of origin? There is free exercise of trade within the common market in the EU, and I think this is a problem that's not really sort of properly discussed at this point, because traditionally legal services and the regulation of legal services follow the principle of the country of destination, whereas digital services follow the principle of country of origin. And so the question is, which sort of principle takes precedent really over the other here? And we are just at the beginning, I think, to discuss all those difficult questions. I feel that we need to be cautious to make very, very sort of lawyer-specific rules for problems which have relevance in other sectors as well. I think that's my point that I would like to make.
Thank you, Matthias. Iris.
Yes, actually, I fully agree with lots of what Matthias just said. And in my introductions, I said that I was part of AUGASOC, this consortium that focuses on how to uphold public values in society, but it more specifically focused on different pillars, like on the justice system, the health system, and the media sector, in order to also to gain cross-sectoral insights, because there are many, of course, common challenges, in particularly, I think, with regard, for instance, to independence, which is really a core value of many professionals. And in this regard, I also echo what Matthias said about that we should, I think, avoid to now, in sort of rather ad hoc way, addressing the risk in legal practice, start up to formulate new rules, specific rules, but also to take into account a more broader and shared risks and challenges. And so in this regard, I think the focus should also not so much be on which rules we perhaps need, but also to how to regulate. And I think the focus on the individual, which is of course already a bit of a problem in legal practice, because lots of what lawyers do, at least in big law, is largely determined also by the context in which they work, by law firms. I think this is a fortiori also the case in the context of working with AI, that lawyers have so limited control over the tools they use for several reasons. And I think in this regard we can perhaps learn also from the debate now on the judiciary, which Matthias very clearly explained is part of judicial decision making. It's a high risk AI, judicial AI is a high risk, can be high risk use, so is regulated by the AI Act, and then human oversight should be in place. And then the debate is about whether judges can fulfill this role as an overseer, the individual judge. And it said no, this is overburdening the judge, to ask the judge to oversee the systems that he or she is using. And then proposals are made for a more institutional approach as well, in addition to the individual responsibility of the judge being independent and also being able to exercise judgment about the tools they use, that these should be supported by the institution and such. And then calls for AI committees, for instance, arise, AI committees on a more higher level in the organization that, with the help of technical experts, can help safeguard these professional values. So I think we should not also overburden the individual lawyer, for instance, indeed, to simply mention in a rule that he should verify the outcomes of AI, but in addition should also think about how to effectuate or protect these professional values by means of higher level institutional safeguards being in place within law firms, either in law firms, and then it's a law firm-based regulation, proactive management-based regulation, rather than this individual reactive approach. And I think also the Bar Association have a huge responsibility here. So it should also be a responsibility of the bar leaders to allow lawyers to use tools that comply with the rules we want to adhere in the rule of law. And just one brief remark in this regard, I'm really positive about the way the Dutch judiciary is dealing with all these challenges, but they really intentionally opt for a learning by doing approach, and then with sandboxes being used, and in this learning by doing, combining vision development with stakeholders and technical experts. So I think on this more organizational level should also a lot of work to be done, and not burden the individual lawyer professional too much also.
Thank you, Iris. Julian.
Oh, you're... yeah.
Sorry, spotted it just at the same time. Yeah, I think I end up probably in a very similar place to Ellis in this one. I start going, if we go back to first principles, maybe some justification for specific regulation in high risk areas. Legal services at the moment in general is not a high-risk area. Even if we had a specific AI Act, it's probably not going to make a lot of difference to legal services. The problem with AI-specific regulation is you run into what we've historically called the pacing problem. Law struggles to keep up with technological change. You make the regulations too specific, you're constantly having to adapt and play catch up with regulation. So the principle of technology neutral regulation makes sense if technology neutral regulation can cover the risks. So it becomes for me, everything boils down in the end to a risk-based question. So long as we're operating with augmented legal services rather than purely AI-delivered legal services, I think once we move into territory of purely AI-delivered legal services, and we're certainly not there yet, maybe some of that risk assessment, risk calculation starts to change. Perhaps quite dramatically. Perhaps we get closer to the concerns we have around the use of AI in judicial decision making, when the AI might implicitly, through triaging and other tasks, start to make sort of distributional and access decisions in and for itself and things like that. If we ever get into that kind of environment. So I'm kind of quite supportive of a slow and steady approach. I do think there are things that we should be thinking about, however, within the regulatory space. One of those is lawyer education, because I think what a lot of the so-called hallucination cases are highlighting for us is just how little lawyers know about and are aware of the risks and challenges associated with AI. Now, some of that may be an issue for us in the law schools, but it's also a continuing issue for those many lawyers who are beyond our reach at the moment because they are in the profession. So it's not going to be a problem that's going to go away super quickly. I think there's also an underlying, at the moment, reliability problem that is baked in, particularly to generative AI. And there's part of me hopes the Gen AI bubble actually does burst and we get something better than generative AI in the next iteration. So I'm not a huge fan of generative AI, precisely because it is so probabilistic and makes stuff up as a matter of design, not as a matter of accident. But what we have as a problem for law firms is a lack of access to reliable knowledge about the tools as well. So a lot of that information is managed by those who have a vested interest in selling the product. So I think there's a big benchmarking problem. And I mean, we can talk about things like Harvey's legal benchmark, which is quite an interesting supplier produced exercise, but it is a supplier produced tool. So what can we do across the sector? What can we do with regulation in collaboration with the universities to get some of these tools opened up to at least produce reliable benchmarks? If we can start to produce reliable benchmarks, we can also then start to talk about the possibility of platform regulation. And if you really want to engage, and I'm going to upset every lawyer in the room, which probably means all of us, to an event like this, if you really then start to engage with questions like platform regulation, then you really start to open up the access to justice question in a whole other way, because then you can start to say, if the platform is reliable, what level of legal service skill and related skills do we need the provider to have? And that, in and of itself, could significantly open up access to justice in a way that legal-centric services and unauthorized practice of law rules currently constrain. So, how much of a grenade do you want me to throw, Helen?
Well, I always rely on you to throw the grenade. You did premise your talk with Aussie football, so I mean that says it for itself. But what it does, Julian, passing on to Nomalanga, she raised, and this is an access to justice issue, is she raised the very first case in South Africa where I think it was Judge Wilson who had said the heads produced by this pro se litigant in his own right, without legal representation, what the heads that had been generated by the AI and checked by this layperson were better heads than some of the heads he's seen by counsel, and that kind of really upset a few people. But yeah, this is one of the themes that's being picked up by Iris, yourself, Norma, as well, with the access to justice issue. Norma.
So I want to talk about minimum standards because you asked us, do we need an overarching policy, rule, legislation for this in particular? And I know the intellectual property lawyers in the room won't like me much for saying this, but you'll remember with TRIPS agreement, where minimum standards were set to sort of provide a floor of principles to work with that nations could then build on. I think the same approach can be used here because of the point that indeed the ethical question is not only for the lawyer. But I also want to pull on an approach we're already using at the WITS Image Rights Engagement now that the AI policy has been retracted. The fact that we are already starting to approach certain departments that have existing mandate that can address certain AI risks and harms. And we're saying to them, you don't have to wait for us to have an AI policy or an AI statute to address the things that fall within your purview or your mandate. In fact, your mandate requires of you to remain agile enough to address the harms and the risks with AI. And I think that's the same that applies to the LPC currently and what we've seen with the Law Society of South Africa drafting regulations, guidelines on ethical use of AI. But there's another layer to this problem, and I think it's more of an internal governance thing for law firms, because many institutions, including law firms, might not be aware of how much AI use is happening within their organizations. Because you've got maybe that junior lawyer there using ChatGPT, the secretary may be using DeepSeek, and you're not aware of that, and it's not pre-approved. Right. It's the same question that I've raised in a different context about how we do things in universities, where we often bring tools to class, but no one has really checked where this tool comes from, how it transmits data across borders, and whether it's safe to use in that context. So it's a question of security safeguards as well that needs to be immediately addressed and can be immediately addressed by organizations by firstly finding out what AI use is already happening. And also determining what are the policies of the AI systems that are already being used by employees, because some employees might download, say, ChatGPT and not switch off the training permissions. And thus anything that goes onto that system coming from the firm ends up in the training model, right? So I really think there's a multi-layered approach. First, nationally, we could have a floor, minimum standards, that each sector could build on. For example, with regard to data protection, the Information Regulator of SA could also give a guidance note, maybe not a code of conduct yet, although there is some mandate for them to impose certain principles. But I think the starting point would be a guidance note on, well, how do you deal with information in certain professional contexts? Yeah.
Thank you, Norma. Brian, you've pretty much given us your views, but if there's anything you want to add at this point.
I think, yes, I've covered most of the perspective of the regulator, but to just answer someone in the comments section with regards to the question that was posed to Dr. Mashinini there, with regards to a person not verifying or false verification and incorrect advice, to state that, as I mentioned, that our code of conduct, we actually focus on the conduct of relating to the duties of a legal practitioner. So whether you use the tool or not, they still align or allow us to discipline or to have jurisdiction over certain issues. I won't recite the code of conduct, but I would advise the person who made the comment to just look at paragraph 1814 of our code of conduct in 311 and also 313. Then they would see that still the LPC or the council would be able to deal with issues of not verifying.
Thanks, Brian. I just wanted to quickly pick up on this last point about the duty of verification. And I recall, Matthias, listening to you in the session you gave to the a conference in Tokyo, webinar for Tokyo, Japan, where you intimated that at some point there may be a duty to use AI. If I recall, so right now there's, you've got your duty of competence and diligence and independence. But at what point do we say, and I think it's implied by Marty Bloom's comment in the chat, that at what point is it you are incompetent if you don't use AI in your client's case? Thanks.
Well, I think that depends, of course, on the development of AI, but it's probably not in an aspect of professional ethics, at least here in our jurisdictions, but more a question of contract law and your obligations you have, because you need to represent your client in the best possible way. I remember a post on social media last week where a judge commented that he can see now submissions by lawyers that are much better structured and sometimes have a better quality because they obviously use AI now, where in the past they sort of sent on rambling statements, unstructured, And he said it actually makes some judges say it makes life much more complicated and difficult for us because you get like submissions of 300-400 pages, obviously generated by AI, and others say, well, the quality is simply better now. Often, I think it depends on the quality of the tools you have at the moment because of the hallucination problems. We are pretty far away from that point, but at some point I think we will get there if there are if you can prove that by using AI, the chances are higher that you get a better result for your client. And yet again, this is nothing new. There has been a court decision by the German Supreme Court that discussed, for example, the duty to use a database, which is also a development we had like 10, 15 years ago. In the past, you would rely on books, then you had databases. And at what point do you have to move from books to databases to represent your client in the best possible way? And now we are at the point where we discuss when do you have to move from databases to AI. So it's, as I say, many of these questions is like old wine in new bottles in a way.
Thank you. Thanks, Matthias. Brian, if I can just call on you, because one of the things that Matthias raises is the, at what point did the duty come from, to use databases and to have a law firm that has databases available to their lawyers. So I mean, one of the things that strikes me in South Africa is we've got many single practitioners, and their knowledge and access to a lot of materials is limited. And you know, whereas our sort of medium and top tier law firms are using LexisNexis, Protégé, or other kind of closed loop AIs, our single practitioners are using open, you know, the shadow effect, I think Nomalanga spoke about, or Julian, where they don't really know how it works, but it's the only access point, if you like, as a single practitioner. I don't know how you could respond to that.
Yes, you are quite correct that we, as the regulator, we've noticed that, yeah, the sole practitioner law firms or those from disadvantaged communities are still not as exposed to AI as the ones, for instance, here in Joburg, and those who can actually afford those platforms. So they're still using the old way of research and drafting and going to the libraries or using the OPC's library platform, which then provides them with the sources for them to draft whatever they need to draft. And we do run the risk with those small firms that would then use not the full equipped AI, which is specifically for that specifically can be used by legal practitioners, and use the generic ones, or the I don't know the word to put it, the ones that are not that expensive platforms, and then get the hallucinated products out of those. And that's where we run the risk of having to prepare some form of guidelines for them to be informed that even if you're using that type of platform, you need to then go back to the basics of going to the library, verifying your information, checking your SAFLI here in South Africa to check the cases and make sure that you have relevant cases that are there instead of fabricated ones. So it is still a risk in regulatory point of view, but we haven't had that much of complaints through the LPC relating to sole practitioners and AI usage at this point in time. But most probably it's something that will come up as people get more and more exposed to it. And that's why we need to develop those type of guidelines, and also, as the regulator, try to find a platform to assist those legal practitioners in obtaining or subsidizing in order for them to obtain the proper AI tools to assist in their litigation, their drafting of documents.
Thank you, Brian. Yeah, I mean, I think this links to Iris is nodding vigorously, just in terms of access to justice, but also, you know, the need to regulate, or I don't know what Nomalanga spoke as the minimum, you know, standards, so that there is a sense of what needs to be done. Because I think the word was, it's obviously the duty to verify is implied, but where practitioners have very limited resources, how do we go about this? I want to turn to the chat, and it looks like some people put their questions on the Q&A and then some on the actual chat. And I'm going to just point out to our participants that Nomalanga has kindly posted two fantastic articles by two of our speakers, which are open access, I'm glad to see. And then we've got and also the Legal Practice Council's webinar recently on AI and the legal profession. The first comment is something I think we have addressed. Dr. Desu, who says, how can countries without AI-specific legislation still ensure accountability and transparency in AI-driven decision-making? I think we have addressed that, but I don't know if anyone in the panel wants to respond specifically to that. Matthias? That seems up your alley.
Well, I think, I mean, at European Union level, you have those transparency requirements in the AI Act, which do not really cover specific problems of the legal profession. I can only comment on the situation in Germany where this has been discussed, and I mean there are various disclosure requirements for or transparency requirements for lawyers, and some of them apply to AI, but not because they are AI specific, but simply existing rules fall within the scope of, you know, what tools you use and how's your practice structured. So I don't think that's a big issue. Probably you have to fine-tune existing rules to some extent, or you can simply, if you feel that's necessary, you can add another layer of transparency duties, which are a common feature of European legislation as well. I think what you need to discuss is to what extent do you have to make a distinction between consumer clients and corporate clients? Is that the same or not? The same level of transparency required or not? I think that's a distinction we have in Germany in various areas, that you have more transparency duties in relation to consumers than to institutional clients. Generally speaking, I don't think it's a big issue, because most of those transparency duties, they come from other sources of law than profession specific regulation which is specific to lawyers. But this is, of course, might be different in other jurisdictions. So
thank you.
Could I just add to that one very briefly, Helen? I mean, at a technical level, I think it is quite an interesting point. If we look, I mean, certainly most common law jurisdictions that I'm aware of, if you look at the way in which the professional conduct rules are drafted, they're drafted as a codification of underlying legal standards, rather than as a freestanding form of law in their own right. So there is a question of legal basis for the power or the duty that I think this does raise. And I think at the very minimum level, if you're saying you don't have those kind of transparency or other duties that are explicitly elsewhere in legislation that can be applied directly or by a very strong analogy, then you might be forced back, even at a sector level of regulation, to thinking, well, is the stuff that we need to introduce here at the level of primary legislation rather than through the conduct rules, or even perhaps through specific secondary legislation. So it adds a layer of complexity and possibly at least delay in making those sorts of changes. Or you go the way that most of our jurisdictions seem to be going at the moment, with dealing with this more fine-grained stuff, which is you bypass that problem through soft regulation and guidelines.
Julian, I'm going to stick with you, because the next comment is Linda Malindisa Mbuli. And I'm hoping you can see the chat on your screen. But this is more about federalized regulation. So his question is whether the Auspublic be better served by uniform regulation of sector conduct when it comes to legal practitioners, as the current system is piecemeal meaning that one client in another state does not get the same protection from guidelines because of differing state approaches. A uniform code of standard could ensure equality and legal certainty, don't you think? Julian.
Yeah. I look. I may have overplayed my own case a little bit on that one in the presentation. So I probably need to fess up here. There isn't a great deal of variation. There's two of the smaller jurisdictions that haven't signed up to what we call the Australian Solicitors' Conduct Rules, which have been promulgated primarily by a lead professional body, the Law Council of Australia. So at the conduct rule level, we're pretty consistent. So in terms of consumer risk, consumer protection, the problem isn't there so much. I think the problem is more of, what is the function of these guidelines that we're starting to see being promulgated by professional bodies and in some cases some regulatory bodies. If these are kind of setting something up above the floor or providing a bit more specificity, then we're starting to look at these guidelines as perhaps more a kind of best practice rather than a flaw of practice in relation to AI augmented legal practice. And so I think insofar as there is a risk, it's a risk perhaps of clients not being, or lawyers and therefore clients indirectly not being exposed to best practices in the area rather than massive variation in the minimum standards.
Thanks,
If I may,
yes.
if I may quickly add to that, I mean, I've had a look at quite a few of those guidelines that exist. The American Bar Association has them, and in the UK you have them. There are two different sets of guidelines by the German Federal Bar, by the German Bar Association, and if you look at them, they all address across the jurisdictions the same problems in pretty much the same way. So there are differences in detail because of different, traditions of, for example, the United States, the ABA has a duty of competence, which we don't know in Germany, at least not as a specific rule. But in general, you don't see anything that would give rise to something you would call a conflict of law or conflict of guidelines, that somebody would deal with an issue completely differently than another jurisdiction, because it's a common theme, because it's the same AI everywhere more or less. So I think it's a theoretical problem. I'm not sure if it's a practical problem, really.
I think the more sorry,
yes.
No, I've had my say. Sorry.
Just a tiny remark in addition to what Matthias just said. I think that's completely right. Although this really specific issue of being transparent to the client and whether the client should provide consent, you can imagine that's a huge issue if you have different rules being in place because of the competition and whatever. I see that one is relevant. And I think there already in the Netherlands, there's criticism on the strict approach, Dutch approach, as compared to the more lenient approach in the CCB guidelines.
Thanks, Iris.
I think if I may add one thing that I just forgot to say. I mean, what we are more discussing is different levels of or conflicting rules, not in different jurisdictions, but within the same jurisdictions, because you have different legal service providers who are regulated in a different way. You have lawyers who are providing legal services, but you also have in Germany lawyers, non-lawyers who can provide to some extent the same kind of legal service. So the problem really is it a good place to deal with those problems on the level of a specific profession, or do you need sort of overarching regulations that all legal service providers are governed by the same rules, so that clients can expect that everybody has the same transparency duties when they use AI? I think that's a discussion we are beginning to have. The problem with these guidelines is that guidelines are always set up by professional bodies, but not by somebody who has all the players in mind, really. And governments usually, or governmental bodies, they don't set up soft law, because soft law is usually, they don't do that because that's out of the sort of traditional way of rule making for them. So I think that's I think the bigger problem we are discussing, or we are facing at the moment, that we have different levels of regulation for different legal service providers within one jurisdiction.
So
and we've also got the litigators versus transactional lawyer problem through court guidelines, which is a variation on that. Sorry, Helen.
So no. So I mean, one of the one of the reasons we had our Legal Practice Act updated in 2015 was the very differing regulation of attorneys and what is to you barristers, what is advocates to us. So you know, there is that problem in many forms in different jurisdictions. But I see we've got 5 minutes left, and I wanted to just pick up on something that Matthias said, which was about the AI is the same across any jurisdiction. And I think I'm going to go to Norma, because the next question is for her on the chat. But also, one of the things that was raised in the previous webinar was the issue of Western bias in these AI systems. And that was a big complaint in that previous webinar, and something that links a little bit to what Iris was talking about in terms of, you know, the way in which these systems are coded and the discriminatory practices that might result. So, Norma, if you can address that issue, but also together with the issue of that's raised by Sipelo Mbuli. Thanks.
I saw the issue in the chat, but let me start with what you asked about the bias, because I really think I want to hop back onto the agency train here, because as a professional, I think it is your duty, you know, to have that kind of oversight. You're not only looking to verify hallucination or fakery, but you're also looking to see where are the lines of the biasness that comes with some of the output that you get from AI systems. And as a professional, I think you are the one who should be making the determination of what you either include, exclude, use, or don't use, you know, because, you know, you are the one sitting, for example, in an African context who picks up the bias, because sometimes what we call bias in African context in a country like the US, to them, it's not bias, right? Because it's the model is trained on a lot of the stuff that comes from there. So this is where like I said, the agency comes in to address not only the opacity, but the bias as well, and to contextualize the output within the scope of your work. Just like what I saw in the comment, one of the legal practitioners mentioned how they now use AI to check what their clients may have found from an AI system, so that they can adequately respond to that. And that is part of checking bias as well, because sometimes your client, being a non-lawyer, could have, you know, been fed information or principles that come from a heavily US kind of notion, or UK kind of notion, because maybe that's what the system was trained on, and may not be good enough to address a problem within the South African context. We saw this early on, initially when ChatGPT came out and we were testing it, that it hardly knew South African law. And that was an accessibility issue, right? Now, the other thing I wanted to touch on, I saw Julian and Brian already answered the question about, you know, the consumer aspect and the suing under delict or tort law. I want to say, even if you look at, for example, the data protection law that we have, Section 99 of the Protection of Personal Information Act allows a data subject to go to court without having to go first through the information regulator if personal information was processed unlawfully. So that remains open to a client to do if indeed a legal practitioner has breached the data subject rights relating to personal information processing. But the common law delict in and of itself, even if we're not dealing with a personal information context, I ask the question, what are its limits? Because if you're not dealing with the Parker versus Forsyth situation where the client had to carry the wasted costs, if it's not that case, what is the loss that you're going to be proving? Because one of the elements of delict in our law is you must be showing not only intention, not only the conduct, but also that you suffered a loss, harm was experienced. So if you can't prove loss, if you didn't pay wasted costs, what would you be claiming for? Yeah. And Helen, my next meeting has started. I might have to hop out while you wrap up.
Well, let me wrap up in 30 seconds. I am just so grateful to our cross-border. The information has crossed borders. It's crossed jurisdictions. We've gone from north, we've gone to south. I'm so grateful for we've got academics who are top in their field, as you've seen from the literature we've shared on the chat. We've got Brian from the Legal Practice Council, which we're so grateful for. And Norma, you're the mensch in all this. Thank you for bringing us all together. And with your permission and with the presenter's permission, we will be sharing the slides that were and were not shared with us. And thanks everyone for participating. It's now 13:01. Julian, you can have a nightcap. No one else is allowed a nightcap now. And thanks very much, everyone, for making the time for this webinar. Cheers.
Thank you.
Thank you.
Thank you for organizing.